Your Honor, Plaintiff's counsel attempts to persuade this court that Mather should not be allowed to enter expert witness testimony to prove that trace amounts of GMOs are within industry expected norms for gin. Plaintiff's counsel argues that because Section 1-303E1 provides that express terms must prevail over usage of trade, that the express terms of this agreement are not open to interpretation. Yet plaintiff complains that Mather breached the contract by providing gin with GMOs. GMOs are not expressly prohibited by the contract. Opposing counsel stated that because GMOs cannot and are not found naturally occurring in the wild, that they are human-made materials. Thus, opposing counsel reasons, their existence in the gin represents a breach by Mather. I would like to make 2 points in response to that argument. First, the contract's term human-made materials is vague and overbroad. Opposing counsel's definition of a human-made material is something that is not found naturally occurring in the wild. However, to use opposing counsel's words, gin cannot and is not found naturally occurring in the wild. As such, gin itself is a human-made material. Thus, given opposing counsel's definition, it is unclear which human-made materials in the gin are acceptable and which are not. It is impossible to create gin that does not contain human-made materials. Second, opposing counsel argues that Mather contracted for a higher level of quality in the gin by agreeing to provide all-natural gin. The term all-natural is also vague and overbroad. Cobra venom, botulism toxin, and plutonium are all natural, but I doubt any of us wants those things in our gin. Opposing counsel stated that the parties were free to contract for a higher level of quality. That is indeed true. Plaintiff was free to contract for GMO-free gin. However, she did not. Next, opposing counsel reminds us of Section 1-303E1's hierarchy of express terms over uses of trade. As I previously explained, the contract did not expressly prohibit the presence of GMOs in the gin. Thus, Mather's introduction of usage of trade testimony does not contradict any express term of the agreement. Even if the contract's terms, as stated, represented express provisions, the court in Nanakuli Paving and Rock Company versus Shell Oil Company noted that usage of trade is, quote, important enough to be admitted always, even for a final and complete agreement, end quote. Additionally, opposing counsel argues that because the contract's integration clause declares the contract to be the parties' complete and exclusive agreement, that neither party can add an additional term. If opposing counsel is suggesting that Mather is attempting to add an additional term, I am confused as to what that term might be. In fact, it is plaintiff who is attempting to add an additional term to the contract, GMOs. Regarding plaintiff's attempt to introduce the phone call as evidence, opposing counsel argues that the express terms of the contract state that the plaintiff was entitled to a 15% discount. However, the contract does not contain the amount of the timely payment discount. Plaintiff's counsel also argues that the contract did not represent the parties' final agreement, and as such, evidence of the alleged contemporaneous phone conversation may be introduced under Section 2-202. Yet opposing counsel has not pointed to any evidence to prove that the agreement was not the final agreement of the parties. In fact, this case is analogous to Intershoe Incorporated versus Bankers Trust Company, where the court found that the parties intended a confirmation slip to be the final expression of the parties' agreement because, quote, the essential terms of the transaction were plainly set forth in the confirmation slip, end quote. The court found that there was nothing in the confirmation slip that indicated that the parties intended it to be a preliminary or tentative agreement of those terms. Additionally, the court in Intershoe stated that Section 2-202 does not require any express evidence, in the writing or elsewhere, that indicates that the parties intended the writing to be a final expression of the agreement. Here, plaintiff's counsel indeed noted that the contract contained specific material terms relating to price, delivery, quantity, and quality. Thus, the contract contained the essential terms of the transaction that the court in Intershoe required to form a final agreement. Additionally, there is nothing in the contract that suggests that the parties intended the contract to be a preliminary or tentative agreement. Further, the absence of an express statement in the parties' contract does not preclude the formation of a final agreement. Moreover, a complete and exclusive agreement, as plaintiff acknowledges this contract to be, by being fully integrated, must include all terms in their final form. Therefore, the contract is a final expression of the parties' agreement under Section 2-202, and as such, plaintiff cannot introduce the phone conversation as evidence. Finally, Mather makes no argument that the plaintiff's payment 3 days before the contractual payment date was not timely. Thus, Mather is not arguing for an inconsistent interpretation of the timely payment term or attempting to add an additional term to the contract. Thank you, Your Honor.